The next case is State versus Roberto Leon. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Do you know how long you'd like to reserve, counsel?
5 minutes, please.
Very good. The court will reserve 5 minutes. I'll be keeping time up here. I'll try to let you know you have about a minute left if you get to that point in your argument. The arguments are being recorded, so please keep your voice up and remain behind the podium. Please make sure to introduce yourself when you come to the podium. You should not use the name of any children, minors, or victims during the argument. I don't know if we have that necessarily in this case, but if you do, please refer to them by initials or the victim or the child or some other designation. The judges have read your brief and are ready to proceed whenever you are.
May it please the court. Good morning. My name is Brittany Knight. I am counsel for defendant and appellate Roberto Leon. I've already reserved my 5 minutes, but I'll say that again as well for rebuttal. So the facts in this case, as we see them, are pretty straightforward and not really a dispute. Our client was charged and convicted of a felony 3, what is called failure to comply, commonly known as fleeing and eluding. It is our position that he should not have been convicted of that felony 3 because the statute requires a judge or jury to find aggravating circumstances exist to elevate that from a misdemeanor 1 to a felony 3. Because we don't believe that aggravating circumstances were met and there was not a hearing or a trial determining that, we believe our client should have been convicted only of the misdemeanor and therefore would not be statutorily ineligible for intervention in lieu of conviction, which is what we moved for and which was what was denied.
But isn't it based on, intervention in lieu of conviction is based on what you're actually charged with?
So it's our argument that that's not actually the case and that it should not be based on what the charge is. We argue that that would strip from the judges any sort of discretion and leave that solely with the prosecutor and eliminate any possible charge of a lower charge than the felony.
So did he enter a plea?
Yes, after we moved for the intervention in lieu of conviction and the judge denied our motion, he pled no contest with the intention and stated on the record of appealing that decision.
In order to be an intervention in lieu of conviction, you must plead to the charge, and the finding is held in advance. So it's all based on what they're charged with by a grand jury process.
So I understand that.
So if you went to trial, then there wouldn't be, the intervention in lieu period would be passed.
So this case never proceeded to trial. We only had the hearing on the motion for intervention. So again, it's just our position that because there was no finding of fact on the record from the finder of fact, be it the judge or jury, that aggravating circumstances existed to elevate this case to the felony level, that the conviction was improper as a felony, and therefore the statute would not have applied to him, and he would be able to be in that intervention program.
Did you file any attempt to or motion to reduce the charge from an F3 to an M1 along with your motion to intervene?
Understood. I don't believe that we filed that. I believe that at that point we had already discussed doing the appellate process. It is my understanding that Attorney O'Brien, who was on this case previously, had several discussions with the prosecutor regarding that. Obviously, I was not involved in those. I did not work for Mr. O'Brien at the time. So, but it is my understanding that they had discussed that. Did you have questions for me further, or would you like me to make some more points?
No.
Wonderful.
Continue.
Thank you so much. So again, it's our opinion that this statute, this intervention in lieu of conviction, is a statute that should be construed very liberally, and it is designed and intended per the legislature to prevent people who are not necessarily violent or repeat offenders from getting into the recidivism, cycling door, open door process of felony convictions. Mr. Leon is 20 years old at this point. He has a couple prior traffic convictions. He has PTSD and clinical depression. He's been in treatment. He's been doing very well. He's had no issues since he's gotten himself together. His mother is also a retired Cleveland police officer, and she and his father have stepped up to really support their son and try to help him get his life together. We believe he's a perfect candidate for this program. The last thing that we want to see is some young kid who has drug and alcohol issues get pushed into that revolving door that gets him in and out of prison and would turn him into a non-productive member of society. Again, it's our position that this statute should be construed liberally to help him We did cite case law in our brief as well, stating that in cases like this where drugs, alcohol are the contributing or at least a main factor, that a lot of times intervention might actually protect the individual and the society better than incarceration. Yes, sir.
Even if your client met the criteria for intervention in lieu of conviction statutorily, would you argue that this judge still has discretion on who gets into that program?
Absolutely.
So even if he was charged with a felony 5, the court still could have.
Absolutely, Your Honor. There's absolutely discretion. It requires a hearing. The judge did hold a hearing on our motion. And absolutely, I would agree with that. You're welcome.
How does the court tell the prosecutor what the charge is? Because to be statutorily eligible for ILC, he could not have been charged with this third-degree felony.
So again, it's our position that he could not have been convicted of the third-degree felony. And because the misdemeanor 3 is misdemeanor 1, is a lesser included charge of the felony, that would necessarily be included in it. So therefore, after a trial and finding on the record of facts that aggravated these circumstances, which would be the serious risk of injury to person or property, that those facts would have to be found on the record by jury or judge in order to convict him of the felony. If those records are not found if those facts are not found on the record by a judge or jury, we would argue the only possible conviction would be the lesser included misdemeanor, fleeing and eluding.
But you do have to plead guilty to the charge, so that would be an admission by the defendant.
So again, I understand that there needs to be a plea of guilty. We pled no contest for this procedural reason because we knew that we were going to be appealing this, and that is why Mr. Leon pled no contest to that charge.
I
He
mean,
did not want to.
you have to plead guilty to be in the intervention in lieu of conviction program.
I understand. Yes, so it would be our position that if my understanding of the statute is correct, the guilty plea would be held in abeyance until the intervention program is complete, and then at that point, yes, the plea would be changed as required by statute, or it would be stricken from his record, again, as required by the statute. The no contest plea was made to preserve his appellate right. Is there anything else that you would like me to ask, or would you like me to give you more information?
Please continue.
Okay, awesome. So I guess those are really the vast majority of our arguments are simply that because these aggravating circumstances were not found on the record by the finder of fact, which would be the jury or the judge, that he should not have been convicted of the felony and therefore would be eligible for the statutory program. Thank you. Do you have any further questions for me? Okay, thank you.
Thank you. You'll have your 5 minutes for rebuttal when it's time.
Thank you.
May it please the court, my name is Stephanie Zaranick, and I am from the Medina County Prosecutor's Office representing the appellate in the state of Ohio. The trial court did not err when it found Leon to be ineligible for intervention in lieu of conviction because he was charged with a felony of the third degree. He was charged with 1 count of failure to comply with an order or signal of a police officer. Revised Code Section 2921.331B states, no person shall operate a motor vehicle so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop. Revised Code Section 2921.331C5A2 further states a violation of Division B of this section is a felony of the third degree if the jury or judge's trier of fact finds any of the following by proof beyond a reasonable doubt. The operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to persons or property. The indictment in this case specified that it was for a felony of the third degree and also alleged that Leon caused a substantial risk of serious physical harm to persons or property. This is similar to a case out of this court, State v. Lewis, in which this court reviewed an indictment for failure to comply, specifying that the charge was a felony of the third degree. The court noted that Revised Code Section 2945.75A1 states that if there is an additional element making an offense a more serious degree, the indictment shall state the degree of the offense or shall allege the additional element, which this indictment did both. The Revised Code also states that in order to be eligible for intervention in lieu of conviction, the court must find, among other factors, that the offense is not a felony of the first, second, or third degree. Leon was charged with a felony of the third degree. Therefore, he is not eligible for intervention in lieu of conviction. Leon is also not the first time offender that the intervention Court of Ohio recognized in State v. Massey, which is 125 Ohio State 3rd 204. He had a reckless operation charge for Cuyahoga County, driving under the influence from Medina Municipal Court, drug paraphernalia in OVI in Ashland, weapons while under disability in Rocket River, no contest to an OVI in Wadsworth Municipal Court, and he committed another crime while he was out on bond.
Counsel, I understand from the court's entry that a hearing was held on defendant's oral motion for ILC. And I should have asked appellant counsel for this question, but is the transcript of that hearing in the record?
Yes, it is, Your Honor.
Okay, thank you.
There was a slight procedural error with the initial written motion. And so then the motion for the oral motion was heard.
Okay, thank you.
If there are no further questions, the State of Ohio would respectfully ask this court to affirm the trial court's denial of the motion for intervention in lieu of conviction. Thank you.
Seeing none, thank you.
Thank you. I would point out that the incidents that happened in Wadsworth and Ashland were the same day as this event. It stemmed from one sort of, I guess, string of bad decisions. Mr. Leon absolutely had a drug and alcohol problem as well as mental health issues. Nobody is denying that. We absolutely know that that's what's going on with him. He's been in rehab. He's been doing programs. He took advantage of a lot of the programs that were available to him in the Medina County Court while he was waiting for the determination of the underlying case. And actually the judge in Mr. Leon's sentencing commended him for taking advantage of those opportunities. So while what the state is arguing is absolutely correct, that he does have prior issues, the three incidents, this one, Wadsworth and Ashland, were all sort of part of one same event. It wasn't 4 or 5 separate days or months or weeks in between. So absolutely, I would just point that out. And I would again argue that even the statute, as the state just read it to you, was requiring that there be a finding of fact regarding the circumstances that elevate the crime of fleeing and eluding or failure to comply from misdemeanor to a felony. Thank you. Any further questions for me?
No, seeing none, thank you very much.
Thank you. We would respectfully request that the lower court's ruling be overturned and Mr. Leon be admitted into the intervention program.
Thank you.
Thank you.
And the court thanks you both for your presentation today. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, the clerk of courts will mail a copy of that to you. The decision will also be available on the Ohio Supreme Court's website.